My name is Autumn Lowry, and I will be your presenter today on the top 5 pitfalls to avoid during an investigation. Before we get started, I do want to go over a couple of things. First and foremost, all lines are muted, so I will not be able to hear you if you're chatting up with me. If you do have any questions throughout the presentation, feel free to type those questions in using the questions or chat feature. We will address all questions that are put through during the webinar at the end, during the Q&A portion. But as I said, if you have any questions throughout the webinar, go ahead and filter them through, and we'll get to as many as we can when we end the presentation. You will be receiving a copy of the presentation following the webinar, no later than Monday, along with some additional supplemental resources. We do welcome any feedback that you have to the presentation and would appreciate any time you could spend responding to the post-webinar survey. There are also a number of other webinars coming up, so be sure to look for those and join us. As I said, my name is Autumn Lowry, and I'm the Manager of Professional Services here at Business Controls. Prior to joining the team here at Business Controls, I did receive my master's degree from the University of Denver and used to work conducting psychological assessments on criminals. I was involved in that process. After criminals have been convicted, I would be called in to do psych testing, clinical interviews, and then help the court make a decision of treatment and whether or not that person was safe to be in society. After spending a significant time in that realm, I opted to get out of it and decided to make a switch over to the corporate world. I initially got involved with Business Controls conducting threat assessments for workplace violence situation and continued my training and education, and am now the manager of our investigations team. As a manager, I oversee all of our investigators as well as conduct investigations myself. Business Controls, we conduct investigations into topics such as employee misconduct, ethics violations, substance abuse, theft, harassment, and discrimination. In addition to the investigations, I also conduct corporate trainings. Some of the most recent topics that I have trained on include workplace violence, sexual harassment, and the process of investigation. Before we get started on this webinar, I'm going to go ahead and out myself briefly. This is the first time that I have led a webinar. As I stated earlier, I conduct private trainings, but this is the first time I'm doing it without a live audience. So you'll have to forgive me if I ask you a question and then have an awkward pause moment because you will not be responding to me. So you can go ahead and forgive me in advance. I'd appreciate it. A little bit about Business Controls. I work for the professional services side, and we also have a technology side. That technology includes an incident reporting and case management software. Business Controls was founded in 1994, and we currently operate in approximately 130 countries and have clients in over 22,000 locations. So let's go ahead and get started with today's topic, top 5 pitfalls to avoid during an investigation. First pitfall to address is not having a sound investigation process. Before an investigation is started, you need to have a predefined and documented process. This is pretty in-depth due to our time constraints here. I'm going to highlight some of the things that you want to make sure are in your process or guidelines. The process should document how your complaints are being received. Ideally, most organizations do have an open door policy. So whether that's related to management or HR, basically allowing individuals to come in and report concerns as they arise. Ideally, an organization should also have some kind of hotline service available so that employees can anonymously report information. Oftentimes when speaking with organizations, we ask if they do have an anonymous option available, and I'm frequently told that they do, and it is in the form of a voicemail system. Employees are not comfortable reporting information through a voicemail, even if it's stated to be anonymous. They fear that if they leave a message, they don't know who's receiving that voicemail, that might be able to recognize their voice and identify them as the reporter. So if you are going to have some kind of anonymous option, I would suggest either having it placed through a third party, so that the individual who's reporting can be assured that they would remain anonymous, or have some kind of call-in system where the information is going to then be transcribed by a third party, again, decreasing the opportunity for that person's identity to be recognized. Another thing to think about is including in the guideline how you are going to assign out investigations and identify who is responsible for actually assigning out those things. Generally, the person you want responsible is going to be a higher level, whether it be a VP of HR, sometimes it's legal counsel, head of compliance, one of those individuals. That person generally will oversee the investigative process, but will assign a specific person to look into the concerns. Organizations determine how they're going to assign issues in a variety of different ways. Sometimes it's by department, sometimes it's by complaint, and sometimes it may get escalated a certain way depending on the seriousness of offense. So you just want to make sure to have those different things outlined, a tree, if you will, to know where issues are going to go and who they should be assigned to. Another thing to include in your investigation is going to be timelines for response and completion of the investigations. Keep in mind, all investigations are different, so we want to set general timelines that if everything goes as planned, these should be met by the investigator. If you are unable to meet those general guidelines that you place, that's okay. There's going to be anomalies. There's going to be situations that fall outside the scope. But just make sure that you're able to clearly document when those situations arise and why you were unable to meet the predefined timelines. So timelines would include response time to the complainant. Typically, you want to follow up with the complainant within 24 to 48 hours. This is as simple as, hey, we received your complaint, we take your concern seriously, and we're looking into it. Somebody will be following up with you shortly. So that follow-up doesn't have to be a formal interview. Just want to make sure they know that you got it and you are working on it. Your timeline also should hit on the completion of the actual investigation, how quickly the investigator is going to be expected to provide a verbal report, and then how much longer it's going to take to actually get that information written up. Here at Business Controls, in general, we have a guideline to complete investigations within 3 weeks from start to finish, and then we'll allot an additional week for report writing. Now, as I said earlier, that can vary depending on the case matter. And we allow for extension time to be granted as long as it has approval. And again, we're going to document why we needed extending, why there are extenuating circumstances. For example, maybe somebody was out on FMLA and they were a crucial witness interview, but you were unable to interview them until they came back. Those are good reasons to fall outside of the predefined guidelines for the timeline. Another thing to include in your process is general steps, or we like to refer to them as phases to follow. So how are you going to actually walk through the investigation? We have 5 general phases that we use here at Business Controls, very high level. The first one we engage in is preparation. So this is when we're assigning who the investigator is. We're figuring out the parameters of the timeline and making sure that we have our management commitment before we move forward. We're also going to go ahead and define the scope of the investigation. The second phase would be information gathering. So this is where we're going to look at documents, review any surveillance footage, and try to get any of that background information that we can before moving into the third phase, which would be interviews. I'm going to go into interviews in a little bit more detail in one of the other pitfall points, so I'm going to leave that one for now. The fourth phase that we go into would be reporting information. So this is going to include a verbal report to the decision makers as well as providing them with a written report. and to follow up with any kind of corrective or disciplinary action. The final and fifth phase of our investigative process is prevention and education. So this is where you take an opportunity to review at a high level what were these concerns, what are the lessons we learned out of this investigation, and what can we do to ensure that this issue doesn't happen again. One of the final things to follow up with in your investigative process, make sure that you are following up with the involved parties. Now, this may be just the complainant, it may be the complainant and the accused, and sometimes you have to follow up with other witness individuals. Sometimes it's important to do some kind of general debriefing with the team as a whole. Again, this is just going to be influenced by the issue and the conclusions of your investigation. Remember that when litigation occurs, the court is looking to see that you used a consistent process to gather facts and that based on those facts, you reached a reasonable conclusion. They will attack your process. I can recall a recent deposition that I was in for a local transportation company. I was in the deposition for about 8 hours. I'm going to tell you that the majority of the questions that I was asked by opposing counsel had to do with our process and procedure and the steps that we went through in general. Of course, there were questions about the specific complainants and the details of the investigation, but most of it was focusing on those processes. The lawyer asked me several times, well, how do you know that those are the steps you took? How do you know that you started with preparation and followed up with your information gathering? I was able to clearly articulate that process. And the reason I knew that that was what I did, even though the investigation happened over 4 years ago, is because that's the process we follow every time. We have a specific process and procedure. We go through every single step the exact same way. And if there had been any exceptions to that process in that particular investigation, they would have been noted. And since there was nothing noted, I knew that I went through that same process. I feel because we had that process down and I was able to very clearly and repetitively walk through those stages, by the time I went to actually testify, I was on the stand for about 5 minutes. And there were no questions about the process. They weren't able to find any kind of holes in those procedures. So I do think, I definitely know in that personal experience that having that preset, predetermined guideline helped our clients out in the long run. Second pitfall we're going to go over today, not utilizing properly pooled resources. When you are determining who needs to investigate a particular complaint, you need to analyze the experience and the personality of those investigators. Do keep in mind that you can either conduct the investigation using internal resources or you can use external resources. You should be taking into account the type of complaint and the identity of the reporting party and accused as to whether you want to go internal with your resources or external. When we provide you guys with the supplemental information following this webinar, we will be giving you a grid that that'll help you walk through how to determine whether or not you have the internal resources available or should go with external. And when I say external resources, I don't mean necessarily you have to hire a third party, but it's an opportunity to consult with experts, review the experience and skills of your internal investigators, and kind of make that determination in a more educated manner. Ensure that your investigators are experienced in the type of complaint. We certainly don't want individuals who work in internal audit conducting an investigation related to discrimination. Vice versa, an individual with skills in employee relations might not be the best person to walk through a fraud investigation. So again, really just pairing up that type of complaint with the resources that you have available. Ensure that the investigator is not biased. Now, as individuals in HR, sitting within your organization, I would assume that most of you guys would be fairly comfortable saying that you are not biased and could conduct an investigation. Unfortunately, your opinion of it is not going to be the most important aspect. So I would encourage you to take a step back and think, if a judge was in a position and looked at your role, would they think that you had the capability to be unbiased? For example, we often discourage individuals like HR conducting internal investigations in which C-level or executive individuals have been accused of misconduct. While as an HR generalist, you may not have a direct reporting structure to the CIO, this individual does have indirect influence over your position and likely may be interpreted that you could be biased to swing the investigative results in that executive's favor. So just something to kind of keep in mind. Again, I know that when I go into an investigation, I have the benefit of falling back on being a third party, and that I'm completely unbiased in the sense that I don't care whether it's occurring or not, and it makes no difference or no impact on me of whether we find any wrongdoing. However, I still need to take a step back, and I need to look at, do I have any other professional relationships with these individuals? How much work do we do with this client maybe in other professional organizations? I need to make sure there's no kind of potential conflict of interest. Third pitfall I would like to go over is waiting. It is extremely important that we are always conducting a timely investigation. I'm sure that this is all reminder information for you guys listening in on this webinar, but one of the biggest things companies have recently been getting nailed on is timeliness. This is going to include your timeliness in responding to the complainant, as well as how long it took to actually wrap up the investigation through determination and corrective action. Nothing is worse than having a timely response to the complainant, a timely investigation, and then you sit on the disciplinary action for a month or two because we're talking with management, we're talking with the union, we're trying to get everything settled out and figure out what kind of corrective action to actually disperse. It is important to have clear and concise follow-up as quickly and as close to the timing of the complaint as possible so that we can make sure that the corrective action is very clearly related to that report and that there's no potential claims there of retaliation. Again, those that are listening here on this webinar, I'm sure are very well aware of timeliness and are on top of this, but you're most likely going to be faulted when these issues are first presented to management and then they're not properly followed up the chain. It is your duty to ensure these managers are properly trained to recognize complaints and to read between the lines. I can think of a recent case I worked on with a client in which HR had a complaining party who was reporting discrimination. They felt that they were treated differently by their manager. The employee claimed that they had previously reported their concern to a skip-level manager and that nothing was done. When HR looked into it, they found out that the employee did report information to that skip-level manager, but the manager said he did not escalate the issue to HR because the employee never complained that they felt they were being treated differently due to their race. However, the manager was able to articulate that the employee said they felt they were treated differently than some of their peers and didn't take that next intuitive step to look at race or even ask that question. So it's, again, important that these managers are educated on reading between the lines. If somebody says, I don't feel like I'm being treated the same as my coworkers, that is a potential for a discrimination claim, and that when they are in doubt, they need to just involve HR. Sometimes we have organizations where managers are unfortunately default too much to HR, and it's a pain for us to try and get them to handle some of their own employee relations issues. But even worse is when we get on the other end of it and the managers try to deal with everything themselves and they don't understand the liability that the organization has or the situation that they're putting the organization in. So that waiting goes back to your management staff. Make sure they are properly trained, and that when in doubt, they're going to come to you and get your input on where the investigation should go. The next pitfall that I would like to hit on is knowing who to interview and why. We generally refer to this as our batting order. So when you are setting up the batting order at the beginning of an investigation, you are going to look at all of the facts. You should always start with interviewing the complaining party. Even if the complaining party has provided information in the form of a written document, it is important to follow up with them to discuss any additional examples they have and for you to get a better understanding of why they feel the misconduct is occurring. Never then jump to the accused individual. Oftentimes when we're reviewing an investigative process, I've seen in writing, companies will have as part of their guideline, the first step is to interview the complainant and the second step is to interview the accused. What happens when you follow that scenario? So you talk to the complainer, they say, I saw my manager engage in inappropriate behavior. I overheard him making an inappropriate comment that was offensive to me. So you go to the manager. This has been a complaint against you that you are making inappropriate comments. The manager then says, no, I didn't. I've never made an inappropriate comment. Now what do you do? Now you just have one person's word against the other. You have nothing to fall back on. So then if you're going to continue your investigation, you start interviewing other individuals, try to get background information. You then have to loop back around with the accused individual. You've lost any element of surprise that you might have, and they now have had more time to prepare a response, and maybe they may have even reached out to some of your potential interviewees and influenced their responses. So we want to make sure that we're setting up our timeline in the most appropriate manner. Now, I know that organizations, when there is an accused individual, will often put that individual on notice or let them know that, hey, there has been a complaint raised against you. We are looking into it. In the meantime, hold tight. Remind you of our non-retaliation policy to make sure that their behavior is in line with it. That's still okay. It's okay to notify that individual that there has been a complaint against them. What we don't want to do is give them all the details of the complaint, and that's okay. We don't have to give them that at that time. At some point before we make a decision, yes, we do have to make them aware of enough information about the complaint so that they have an opportunity to respond. But there's no judgment, there's nothing out there that says we have to tell them immediately when we have the complaint. So again, if your organization has policy or procedure surrounding you putting that accused individual on notice, fine, not a problem. Just be selective with the information that you're sharing with them at the beginning so that you're maintaining the integrity of your investigation. So going back to that batting order, we are always going to start with the complaining party. The next place we want to go is talk to direct witnesses. So if your complaining party was able to identify any direct witnesses in the example I provided, for example, to the offensive comments, that's the next place you want to go. If the complaining party was unable to identify any direct witnesses, you may want to look at the physical setup of the office. See where individuals are typically located, see where the alleged comment was made. If you can determine that location, you can then follow up with other individuals who frequent the area or who may typically work in that area to see if they overheard anything. After, in addition to speaking direct witnesses or identifying those other peers who may work in the area, we typically like to interview the supervisors. So that's going to be the supervisor of the accused and or the supervisor of the complaining party. Supervisors, depending on the structure of your organization, often can provide additional context. So they're going to be able to talk a little bit about the work environment. They're going to be able to talk about previous complaints, previous issues that have come up, whether it's interpersonal, personality issues, or whether they're performance concerns. Those supervisors ideally are at some kind of management level. They're going to be good allies for you throughout the investigation to give you that kind of context. The supervisors can also provide you with information such as who are these individuals' allies, who are their enemies. So if you have a complaining party that identifies two people they would like you to speak to, and they say, well, Tom and Larry know that this has been happening to me. They've witnessed it, or I've told them about it, and they're going to corroborate my information. Great. So your complaining party has identified two people for you to interview. We're definitely going to want to chat with Tom and Larry and see what they have to say. However, what if the supervisor tells you, yeah, Tom and Larry are best friends with that complainant. In fact, they go out to lunch every day. Well, we're going to want to take that information into account when we're looking at the investigation and at the credibility of the information that is being shared. So we're going to want to go ahead and talk to Tom and Larry. But you know what? I'm also going to want to talk to one of the complaining party's peers that doesn't frequently interact with her on a personal basis, that isn't engaged in those social interactions, to make sure that we're getting a neutral and balanced information. If there are no direct witnesses, it's still important to speak to other individuals so that we can look at the character of the people involved, so the character of the accused and the character of the complainant. I think one of the most frequent things that I find in conducting some of these employee relations investigations is you have an employee complaining about their direct supervisor, that they're not being treated fairly and they're being picked on. Well, after you speak to some people, I typically find two responses. Either that manager is just kind of mean to everyone, kind of tends to pick on everyone, kind of tends to just be is really hard-nosed and really harsh in reviewing their performance. Or the other side of it is that manager isn't viewed by other people as being harsh, isn't perceived by others as picking on anyone. In fact, the complaining party has a pretty solid performance issue and was just recently written up for it, or was just recently placed on some kind of performance improvement plan. So those are the kind of environmental or contextual information that we're hoping to gather by pulling those random individuals or those non-direct witness people. Make sure that you are balanced in who you choose for interviews. So again, that goes back to allies and enemies. You're going to find people that really dislike certain individuals, and you're going to find people that are really buddy-buddy with certain individuals. And that's okay. That's all information, and it's all data points that we want to take into account. But we've got to try and find some of those neutral individuals, some of those people who aren't named. When I get people, I often ask the question during interviews, is there anyone else that you think would want to talk to me? Is there anyone else that you think would want to share information? Those names that you get are good people. They're good leads to go off of, but you got to assume that some of those people are going to be the people who have the most harsh opinions in the matter because they're the ones who are most vocal about it. So we want to get that information, but we want to keep it in context and maintain and keep in mind the credibility of where it's coming from. When determining who you're going to interview, the last point I want to make in regard to the batting order is comparators. So this most commonly is going to come into play when you have more of those EEO types of claims. So we're looking at discrimination and retaliation. So if you have, the comparators are there for you to establish a baseline. We want to make sure that we have spoken to other liked individuals that are in the same situation, as well as those who hold the opposite stance on that. So what I mean by that, I'm going to flesh that out a little bit for you guys. For example, if you have an African American employee complaining of differential treatment by their manager. You want to be able to identify any other African American employees that currently or previously have reported to that same manager. If you can't find any, if there aren't any, I would go to the next step and identify any minority individuals that may have reported to that individual. Those are going to be some of your comparators. So we want to say, okay, this individual feels like their differential treatment is influenced by race. Is there anybody else here who has also felt that way that holds a similar protected class category? On the other side of that, I'm going to want to speak to somebody who's not in that protected class. So in this example of using African American, I would want to try and seek out a Caucasian employee who has also reported to that same supervisor and see if that Caucasian employee has had similar issues with the manager or if they haven't. And so that's going to help me take into account the information in a discrimination claim. The final pitfall that I would like to address is over-investigating. Over-investigating is one of the most common errors made by investigators. It is important to set the scope of your investigation at the onset. So that goes back to that preparation phase that I briefly highlighted in the process of investigation. If you set the scope at the beginning, meaning the report or the concern is about X, you can always go back to that scope. As we know from experiencing investigations, the details and facts can often be overwhelming. You get knee-deep in investigation, you've talked to 5 or 6 people, and you can no longer tell which way is up. If you have pre-set that scope, you can go back to it, see where the information, where you originally set it, and determine, okay, am I going off on a tangent? Is this information relevant to my current investigation and can really refocus you? Now, all information that we gain during an investigation is important, but some of it might not be related to your scope, or it may have to be spun off into a separate investigation. Setting the scope at the onset is absolutely going to keep you organized as you walk through the process. There are several questions that investigators here at BCI use as a staple during our interviews. These questions will elicit quite the wide array of responses. One of them is the question, do you know why you're here today? We tend to start out with that question during an interview to see if the person can put us in the right direction so that we can best maintain confidentiality of our other interviewees and of the information that we have. However, the negative byproduct of that is you can get people going off on 5 or 10 minutes of why they think that they're there, and that has nothing to do with why you've actually called them down. Their answer, again, may be giving you some important information. They may be sharing other stuff that you had no idea about it, so we want to be sure to document it and let them talk. But we don't need to follow up asking them a lot of questions. You need to remember that that is outside of the scope of the particular investigation that you're working on. And while it's noted, and you may follow up with them at a later time about that issue, you're going to redirect them so that you can talk about the current investigation. The other question that we frequently ask at the end of an interview is there anything else that you would like to share with me? It's that really broad, open-ended response that elicits wonders of things. Typically, what individuals share is important. We often get really good nuggets with that last question. I encourage that to be a way everybody ends every interview with an individual. They'll sometimes be able to provide you with information that you missed, a question that you just quite didn't get to, or a question that you didn't even think of. On the other side of that, they'll bring up, oh yeah, I have some problems with the lunchroom, or maybe there's an issue with the security camera, or maybe they had problems badging in or clocking in or something like that. Again, it may be completely unrelated to your current investigation, but still good information for you to record, and you may follow up with that at a later time. You should be conducting the investigation until you have enough information to reach a reasonable conclusion. So when we're walking through interviews and looking at documents, we will continue to interview people until we feel we get to a place that we have reached a reasonable conclusion. Just because the complainant gave me 6 names to follow up with, if I get to the 3rd person and I feel very solid in my conclusion, I don't need to interview the other 3 people. It's not necessary. It's a waste of time. It's a waste of resources. That's what we refer to as over-investigating. So once you have enough information that you feel you can reach a reasonable conclusion, stop. Go ahead and wrap up the investigation and get the stuff documented. Now, I've thrown out the words reasonable conclusion a couple of times, and that is in reference to knowing your standard of proof, which is going to help keep you from over-investigating. Here we like to use a football analogy. I think it's most appropriate with it being football season at this time. But there are 3 main standards of proof that are used in the court systems. The first one, beyond a reasonable doubt. This standard of proof is going to be used when referring to criminal investigations. This is our 99.9% threshold. So we are darn sure, smoking gun in our person's hand, that this is the individual who engaged in the behavior. Beyond a reasonable doubt is a very high standard of proof to meet. The reason it is set so high is because in criminal cases, there's the potential for the individual to lose some of their basic rights. So that's why it has to be set so high. But again, that proof only applies in criminal cases, which is not where our investigations are being tried. The second standard of proof is preponderance of the evidence. This is the standard of proof that is used in civil cases. Preponderance of the evidence is that 51% more likely than not. This is where most people, internal investigators, are comfortable sitting. This is where most of us want to get to. It is more likely than not that person engaged in X behavior. However, this is not what the court has put forward for internal investigations. As an internal investigator, we are required to conduct a good faith investigation, and based upon the facts learned throughout that good faith investigation, we reached a reasonable conclusion. That's all we have to meet. So looking at a football analogy, our beyond a reasonable doubt is taking that football from one end zone all the way to the other end zone and getting that touchdown. When we look at preponderance of the evidence, that's really taking the football from one end zone across the 50-yard line. So we're just kind of getting in the other team's side of the field. Good faith investigation is taking that football out of the end zone. So whether we're, it's not quite the touchback, but we're actually running that football out of the end zone and getting somewhere with it. That's where we need to sit. So when you have run-of-the-mill employee relations issues, good faith investigation, reasonable conclusion is the only place you need to go with that standard of proof. Now, when your employee relations complaints raise to the level that it becomes legal, so we're talking about federal claims, EEO, labor claims, things like that, that's when we tend to recommend that you reach more of that preponderance of the evidence threshold, because that is what the court's going to hold you to if it actually gets to civil litigation. So that's where we sit with the standards of proof. Really important to keep those differences in mind so that we are not over-investigating a matter and we're using our time and resources as they need to be used. All right. So it looks like I've gotten through the material pretty good timing here. So this is an opportunity for some questions and we'll provide answers. Feel free to type in any questions as you have them. I know we have a couple that came through already throughout the presentation, so I'm going to go ahead and start addressing those. One question we have is, how does the investigative process change when an attorney is involved? That is a really good question. If you do have an attorney involved, whether it is an internal general counsel or using external counsel, it is going to change the process a little bit. I would tend to recommend to go with whatever your legal counsel, whatever direction they're giving you. But the whole point of bringing in an attorney is so that you can protect the information. So you want to make sure that any email correspondences you have with other individuals have the attorney copied on it, and that any written report that you are submitting is being submitted directly to that legal counsel and marked as attorney work product. Therefore, you can check the integrity of it, and in case anything does actually go to litigation, you can say that you have marked the information as such. Another question we have is, can you tell us a little more about scope and perhaps an example? So a scope of the investigation. Generally, the scope should be able to be determined after speaking to the complaining party. So when you have an opportunity to talk to the complaining party, you're going to be able to understand what their concerns are. And then you would be talking with whatever, if you're the head person or if you have a manager over an investigative team, you'd want to do some kind of team consulting, say, look, this is the person's concerns. How do we need to investigate this? Sometimes people have concerns all over the map. So we've got my current manager is picking on me and calling me names and belittling me in front of our clients. Oh yeah, and I also applied for this position back in 2005 and didn't get an opportunity to interview, and I think it was because of my race. Oh yeah, and then I was out to lunch the other day, and I overheard one of my coworkers talking about this other manager, and that they heard the manager engage in some offensive comments or derogatory comments. Well, that person has just put out 3 totally different claims. That is a lot of work if you try to wrap that all up in one investigation. It's going to get very muddled, and it's not going to be, it's going to be harder to reach clear, concise, reasonable conclusions. I would recommend scoping it out in the sense that you set either separate investigations so that they're not all these issues aren't going to be combined into one report, or perhaps if they all seem to have a consistent theme, say race is a consistent theme throughout it, then you want to set that would be your scope. So the scope of the investigation is differential treatment based on race, and the following are 3 different examples of when they've experienced that behavior. So again, it's just kind of an organizational tool and really setting objectives at the forefront of the investigation. Another question is, when do the police get involved during an investigation? This is a very common question when investigations are surrounding issues of fraud or theft, or sometimes workplace violence concerns such as assault or battery. Anytime an employee engages in behavior that not only is a violation of company policy, but also is potentially a criminal behavior, organizations frequently would like to default to the police. We always recommend against that, and I'm going to try and articulate as clearly as I can why. Now, I'm not saying that you should never get the police involved. I'm just saying you need to think about it, and you need to think about when it's most advantageous to your organization to bring the police in. So what happens when you call the police because you think that there's some kind of issue of theft? Well, the police are going to roll in your organization. They're going to be extremely disruptive to your process if they answer your call. Sometimes police will determine that that is an employee matter, it's a company matter, and that they're there for the public, so it's not something that they need to be concerned with. If they do decide to be concerned with it, they're going to come in, they're going to be disruptive, they may take computers, they may take documents, and are not going to care about how that affects your productivity or the running of your company. Once the police get information, they do their own investigation. So what are you supposed to do with the employees while the police are conducting their investigation? Are you going to put somebody out on leave and pay them for all that time? Are you going to let them keep working, which could increase your liability that you were aware of a situation and didn't immediately intervene and do something to make it better? Once the police finish their investigation, it's up to them to report the information to a district attorney, and then that individual has to make a decision of whether or not they're going to prosecute. Once they decide if they are going to prosecute, they then have to go through that process. So as you can see, this can be very timely. It can take a year or two for the police to go through their investigation, get the DA convinced to actually prosecute, and then go through that process. Again, what have you done with this employee in the meantime? Did you terminate them? If you terminated them without having a sound conclusion from the police, meaning a conviction or some kind of plea, you are now setting yourself up for a wrongful termination claim. So it is extremely important that before you call the police, before you get them involved, you first conduct your own internal investigation. Your burden of proof is much lower than the police. You can reach a reasonable conclusion with your internal investigation, make your decision regarding termination or disciplinary action. Once you have completed that and have enacted that discipline, then you make that decision of, do we want to try and prosecute? Do we want to turn this over to the police? At that point, you've gotten rid of the problem, you've dealt with the employee appropriately, and then if you're trying to get some kind of restitution or what we often hear is wanting to make an example of the employee, so you want to get them arrested or something like that, you're done with it, and you flipped it over to the police, and it's up to them to make their decisions independent of yours. So it's really important to be separating those two decisions. You're also at the advantage of where you can just flip over your final report to the police and give them a head start on their investigation, more likely speeding up that process. The only exception I have to waiting on getting the police involved is involving child pornography or anything like that having to do with a child. There is an absolute duty to immediately report that information to police. So if at any time you discover any of that on anyone's computer, again, that's specifically related to children under the age of 18, any kind of pornographic images, videos, anything like that, you have to immediately contact the police. Outside of that, there is not a duty to notify the police, whether it's drugs, theft, anything like that. It is on company property and company time, so those are your decisions to make internally. All right, next question. So what is the liability when a manager fails to report information to HR in a timely manner? This is a huge liability. Your managers are considered agents of the company. So they are, if they fail to appropriately provide information up the chain so that it can be dealt with, the company will be held responsible. It doesn't matter if nobody except the manager ever knew about it. Once someone that's in management level is made aware of a concern, it is as if every decision maker in the company is being made aware of concern. So that's why it's important that we have the proper training so that management knows when to get other people involved. Management understands when people are making complaints, the type of liability or the positions that they could be putting the organization in. There are kind of two questions that have a little bit of overlap. One was more information about internal versus external resources, and the other being if we don't have a full-time investigator, how can I, as an HR generalist, ensure that I'm performing a thorough and lawful investigation? So I briefly talked about the internal versus external resources, and we are going to give you that grid to kind of help outline when you should go one way versus the other. But if you are that one sole HR person that is having to deal with all of these issues, there are ways to improve your skills. There are plenty of trainings. There are free webinars such as the one we're doing right now. Other companies, law firms, there are plenty of free resources out there available. I would encourage you to look into purchasing research materials, so whether that be actual books on how to conduct investigations, and to also be set up through links so that you're getting updated information as court rulings are being or as court rulings are coming down. Every day there's new court rulings related to employment law, and it changes the way we need to be doing things. So you can get set up free alerts, whether it's Google alerts or being set up on certain company web emails. There are plenty of individuals that are blogging on this kind of stuff, and that's all free. So really encourage you using the resources that are out there and free to you. Secondarily, there are trainings available. Business Controls does put on trainings on how to conduct proper investigations, outlining really specifically the process and procedures that you need to follow. There are other organizations that put on similar trainings, and consulting what you have. So if you have general counsel or if you have external counsel that is available to you as a resource without having to pay their hourly fee, so they're available to consult with you on an as-need basis, call them up, use it. If you work with any kind of third parties that do investigations, utilize those resources. Often I know that we're very accessible to our clients and willing to provide free consultation services just to make sure they're on the right page. So look at the vendors that you're currently working with and try to utilize those resources as much as possible. If you determine that an investigation is above your expertise, or you just don't have the internal resources, whether that be the time or expertise to deal with it, there are plenty of external companies available to conduct investigations for you. If you are going to look for an external company, I would encourage you to shop around and ask for individuals to provide you with a sample report as well as a sample invoice, so you can determine how professional it is, if the report is written in a manner that's thorough and has the level of quality for what you're paying for. Also, just ask some questions. Get those vendors on the phone, ask consistent questions across the board, and see which ones you think are going to fit in well with your culture. Another question. How do you investigate he said, she said situations? So this kind of goes, I was touching on this briefly when we looked at the batting order of interviews. Sometimes you will have a case where there are no direct witnesses, and in those situations, we need to be looking at credibility. So that's why we're going to speak to supervisors. We're going to talk to other peers who work with both individuals so that we can determine character. You want to determine the credibility of the reporting party as well as the credibility of the accused individual. If someone cannot be truthful about some aspects about some questions that are asked that aren't related to the claim, that's going to decrease their credibility in the answers that they give to the questions that are directly related to the claim. So those are the types of things you want to look into. Now, I could go off for probably another hour on he said, she said investigations, how to properly document that information, how to properly conclude credibility, and then get that in the form of a written report. Fortunately, we don't have the time to do that today, but I do know we will be following up with another free webinar on that topic. So I'd encourage you to keep in tune, looking on Business Controls websites, and log in to get more information about that. All right, I think we are about at the end here. So I really appreciate your time. Thank you for sticking through this with me on my first run. Hopefully it wasn't too awful on your end. It's a little awkward talking to myself over here. Again, we would really appreciate that you follow up and give us any kind of feedback in this post-webinar survey. And if you guys have any questions, I have my contact information provided on this slide. Please don't hesitate to reach out with any kind of questions, whether it's regarding our business or any of the content that we provided to you today. Again, thanks for your time, and we will be following up with some supplemental information. Have a great week.